I'm Sarah Keogh, I'm a barrister at Old Square Chambers. I'm a specialist in employment law and I've been dealing with junior doctor matters for a number of years. Whistleblowing is the common term for reporting concerns about wrongdoing in the workplace, and in UK employment law we call that making a protected disclosure. In the NHS that commonly relates to patient safety, but the law also applies to disclosures about criminal behaviour, breach of legal obligations, health and safety, environmental issues, that kind of thing, provided that in each case it's in the public interest to report the wrongdoing. Protection is obviously important because it allows workers to raise concerns without fear of reprisals from their employer. Well, when junior doctors make a protected disclosure, they're fully protected in employment law from detrimental treatment by their NHS employer. It's not clear, however, whether Health Education England is also an employer within the meaning of the Employment Rights Act 1996. The term employer in this context is much wider than the usually understood meaning, where there's an employee under a contract of employment. It's been alleged in an ongoing case that a doctor under a training programme with Health Education England is a worker of Health Education England under the extended definitions of worker in section 43K of the Act. And the Employment Appeal Tribunal found in February 2016 that that doctor wasn't a worker under this section and Health Education England wasn't his employer. As a result of that, junior doctors currently aren't able to bring proceedings in the Employment Tribunal on the same basis, and that presents a gap in the law. The Health Education England agreement was suggested by the BMA as a way to close that gap without having to rely on the much longer processes of attempting to change the law or a successful legal challenge to the EAT. Health Education England, on their part, has accepted that it can have a significant influence over a junior doctor's career, and it recognises the need for doctors in training to be able to raise issues in the workplace without fear of reprisal, so it also agreed to enter into these negotiations. Those were undertaken in parallel with the main terms and conditions of service negotiations with the government, and I was instructed in May this year to draft and negotiate the terms of the agreement on behalf of the BMA. It took a few months to reach a final agreement because there are 4 teams of lawyers involved, but what I think we've achieved on behalf of junior doctors is an agreement which is very full and robust and effective. The BMA and Health Education England aren't in a position to simply rewrite the Employment Rights Act themselves, so it was agreed to approach it on the basis that protection be provided with a contractual arrangement rather than a statutory arrangement. It's really a series of contracts, and the parties to the contracts are Health Education England and individual NHS employers. The agreement then uses a legal mechanism in the Contracts Rights of Third Parties Act 1999, so that once it's entered into by one of those employers, the doctors in training specified in the agreement are entitled to enforce all of the contractual rights contained within it against Health Education England. So that way they get all the benefits of the agreement without having to be a party to it themselves. The agreement is actually already in force. There are some employers who've already signed it, and it's been made retrospective with effect from the 3rd of August 2016. Well, the term junior doctors isn't a legal one, so we've had to take care when we were drafting the agreement to ensure that it covers the appropriate categories of doctors in training. Under the agreement, these are referred to as postgraduate trainees. The categories are pretty broad. They include all doctors in training in England who have a contract of employment in the NHS under the old National Terms and Conditions, the 2016 National Terms and Conditions for junior doctors, or under a different contract for foundational specialty training with an NHS Foundation Trust. And that's provided in each case they've been appointed by Health Education England and they hold a training number with Health Education England. The agreement also extends to doctors in a GP foundational specialty training programme and to equivalent categories of junior dentists. We also made sure that doctors are protected when they're attempting to commence or recommence this type of training. So, for example, the agreement will cover junior doctors taking time out of programme.